Good afternoon. This is an oral argument on the petition of Respondent Larry C. Grossman for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondent will argue first, and I understand is reserved 8 minutes for rebuttal. Okay, Mr. Messi, you may proceed.
Good afternoon. My name is Zachary Messa. I'm with the law firm of Johnson, Pope, Boker, Rebuttal, and Burns, and I represent Larry Grossman as a respondent in this matter. For purposes of this oral argument, there is really one discrete issue that the respondent wants to address, and it's whether, in light of the decisions in Gabelli in the 11th Circuit and Graham, whether the claims against Mr. Grossman for penalties and disgorgement are barred by Section 2462 5-year statute of limitation. Gabelli was faced with this issue regarding the tolling of a statute of limitations for purposes of penalties. And Gabelli, the court in Gabelli, established a bright line test as to when the statute of limitations begins to run. And that bright line test is when the claim first accrued. Now, the underpinnings of why Gabelli, the Supreme Court in Gabelli, instituted that test was because they wanted to provide a fixed date when the exposure to a governmental enforcement would end. They also wanted to prevent the revival of dead or stale claims to where the evidence has been lost or witnesses' testimony has faded or witnesses have simply disappeared. And finally, one of the things that the Supreme Court in Gabelli did do is that they held the SEC to a higher standard as the enforcer of the securities laws. And under that higher standard, they believed that the SEC had the resources necessary to timely pursue claims within 2462's 5-year statute of limitations. Now, Gabelli did not address disgorgement. And the reason why it didn't address disgorgement, because it wasn't before it. Just because it didn't address it doesn't mean it precludes it either. The disgorgement claim was dismissed in the lower court's proceedings without prejudice by, I believe, the division, and it was never ruled upon by Gabelli. However, the underpinnings in Gabelli would still be equally applicable to claims for disgorgement. Now, after Gabelli was decided, Graham v. SEC was coming about down in the Southern District of Florida, which is really the backyard from where this case emanated. Graham made it up to the 11th Circuit on the issue of whether 2462's statute of limitation also applies to claims for disgorgement. The 11th Circuit basically held that under the 2462 forfeiture was essentially tantamount to disgorgement. And therefore, the bright line test as espoused in Gabelli is also equal to claims for disgorgement.
Can I just ask you a couple questions about that? I mean, first, in Gabelli, I mean, wasn't the issue there really, when the statute on penalties, civil penalties, concededly, when I think everyone would agree, within the statute of limitations provision, when it accrued, either, discovery or when it actually occurred. And as you point out, the court was very clear that they weren't, reaching or deciding anything about disgorgement or other, kinds of equitable remedies. And I guess the other question I have is, I mean, Graham is an expression of the minority view on the point you're arguing, isn't it?
Well, to the extent that you said that Graham is the minority view, I believe that there are numerous district court cases that have distinguished Graham. However, post-Gabelli, I believe that Graham is the only appellate court decision to specifically either say yay or nay to whether or not disgorgement falls within Section 2462 statute of limitations.
Your argument is that Gabelli somehow pertains to disgorgement just based on its discussion of the issue that was before it.
No, I am not saying that Gabelli specifically addressed the issue of disgorgement. What I'm saying is that Gabelli opened the door to establish the bright line test as to when fines, penalties, and forfeitures first accrue, dispelling the myth that the discovery rule applied. And in so doing, Graham came in once they opened that door and found that disgorgement is tantamount to forfeiture, thereby applying the same bright line test that the court in Gabelli applied. In this case, the OIP was filed on 11/20 of 2013. So applying the standard math, applying the statute of limitations period within 2462, the limitations period would begin on November 20th, 2008, up to the date of the filing of the OIP. Now, Grossman proceeded to final hearing in this matter, and upon the conclusion of the final hearing, the ALJ, Judge Murray, issued her initial decision. And in that initial decision, she found that almost all of Grossman's violations of the Securities Act, the Exchange Act, and the Advisor Act occurred during his ownership of Sovereign. But interestingly, and I think it's been undisputed in this case, is that Grossman's ownership in Sovereign ceased on October 1st of 2013. He sold the investment advisory firm to Gregory Adams. And at that date, he was no longer the owner, control person of Sovereign.
I have a quick question on that. Did Mr. Grossman continue to refer clients to Sovereign after he sold the business to Mr. Adams?
After he sold the business to Mr. Adams, Mr. Grossman there is some communications, email communication, to where he referred a client that came to him from Sovereign International Pension Services, which is an IRA administrator. He referred that client over to Sovereign to see if Sovereign could help them with his needs. But the underpinnings in the claims against Mr. Grossman were investments into the Batu funds, which were the Diversified One Fund, the Anchor Hedge Funds, and the PIWM. Those were the funds to where the ALJ found that Mr. Grossman had received fees which were not adequately disclosed to sovereign investors. So just by virtue of referring a SIPS client to Sovereign does not necessarily mean that that Sovereign client would have been invested in any of the funds that were at issue in the underlying proceedings or before the ALJ. And there is no evidence to that effect. So basically applying the underpinnings of Gabelli and Graham, Mr. Grossman's argument is that the claims for penalties and disgorgement are barred by 2462's 5-year statute of limitations. We do concede at this point, as espoused in Graham, that the injunctive relief is forward-looking and therefore would not be subject to the 2462's bar. And that was outlined in Graham, and I believe that is pretty much the state of the law at this point in time. Now, the underpinnings in Gabelli are the dangers that the court was guarding against of faded memories, witness disappearing, documents being lost. We had a lot of that occur during the final hearing with the ALJ. One of the primary witnesses, Mr. Nikolai Batu, he was essentially the advisor for the Anchor Fund as well as the Futures Ones Fund and the PIWM managed account, which is Private International Wealth Management. He disappeared. In September of 2012, the SEC couldn't even get him back here to the United States after they filed an action against Mr. Batu in federal court. So we were unable to bring him into the proceedings as to testify as to what was actually contained in the underlying funds. In addition, a lot of the witnesses were required or questions about documents and circumstances that happened over 6 years ago or over 5 years ago, and naturally they couldn't remember the specifics. For instance, a lot of the witnesses couldn't remember whether or not they received the Form ADV Part 2 from Sovereign International Asset Management. And that is pretty significant because that would be one of the duties as an investment advisor which they would have to furnish to their clients. Likewise, the same would happen with regards to the private placement memorandums. So notably, in the judge's opinion, at pages 32 through 42, all of her findings or violations of law were all confined to Mr. Grossman's ownership of Sovereign. However, the ALJ went beyond in determining the amount to assess penalties. What she did is she went ahead and looked at some of the conduct that occurred while Grossman was an independent contractor or a consultant for Sovereign. And she found that there was violations during that period which would allow her to go ahead and reach outside of the statute of limitations in order to determine penalties. However, during the hearing, it was consistent testimony by Greg Adams as well as Mr. Grossman as to what his duties were at Sovereign when he came back on as a consultant. And when he came back onto an consultant, it was a very troubling time in the financial industry. Right around 2008, 2009, the financial industry was experiencing great turmoil. So he came back on, and he wanted to help Mr. Adams complete the transition of his business as well as deal with some issues regarding this turmoil. At no time did he render investment advice. Now, for instance, Ms. Van Dyke was specifically questioned as to whether or not Mr. Grossman rendered any investment advice to her regarding the underlying securities. She said, no, he didn't, not during the limitations period. However, the ALJ focused on really two documents, which I think were the key underpinnings as to her conclusion that Grossman was something more than just a mere consultant at Sovereign. And the two documents would be the IRAD disclosure document at Defendant's Exhibit or at the Division's Exhibit 2. And that IRAD document showed that Grossman was a registered representative of Sovereign from the mid-90s up into the present. However, what the ALJ overlooked is that on page 1 of the IARD, it specifically states that this document was not updated until August 16th of 2006. Likewise,
Mr. Besser, your initial time has expired. Go ahead and finish your thought, though.
Yes, I will. I'll just reserve my 2 minutes at the end. In addition, page 4 of the IRAD specifically says an employment end date of, quote, present may not reflect the investment advisor representative's current employment status. So reliance upon the IARD to show that Mr. Grossman was anything other than a consultant, we believe it was an error.
Thank you.
Thank you.
Thank you. Mr. Costello, you may proceed.
Good afternoon. Patrick Costello on behalf of the Division of Enforcement. Chair White, Commissioners, the Division would like to thank you for the opportunity to address the Commission today. The Division has 3 arguments that it would like to make this afternoon. The first is that the respondent, Larry Grossman, has waived the argument under Graham that disgorgement constitutes a forfeiture, and thus the Commission need not actually reach a decision as to whether or not Graham applies in this case. The second is that even if there is no waiver of the Graham issue, that the Commission nevertheless should still decline to follow Graham, and that is to be consistent with the position that the staff has taken on behalf of the Commission in appeals currently pending before the 2nd, 8th, and 10th Circuits, and also because Graham was substantively decided incorrectly, which I will get to in a moment. And the third is that as far as the civil penalty is concerned, the Commission can still sanction Mr. Grossman with third-tier civil penalties based on misconduct that he committed within the limitations period. Now, the law judge properly found that Mr. Grossman had breached his fiduciary duty to his clients. These clients were retirees who had invested their life savings with Mr. Grossman and depended on him to take care of their hard-earned money. Rather than doing that, however, Mr. Grossman decided to personally profit from his clients' inexperience and dependency on him, and he recommended that they invest their life savings almost exclusively in these so-called anchor funds. He had told the clients that he had conducted extensive due diligence on these funds, that these funds were safe and that they were properly diversified. Turns out, however, that Mr. Grossman did not conduct extensive due diligence. These funds were not safe, and these funds were not diversified. Instead, they were feeder funds that consisted of layer upon layer upon layer, ultimately trickling down into Madoff. And sovereign clients, at the end of the day, lost millions and millions of dollars. But to Mr. Grossman, that didn't matter. And the reason it didn't matter is because the safety of these funds and the diversification weren't the only things that he was being dishonest about with respect to his clients. He also did not tell them that he had profited to the tune of almost $3.5 million in kickbacks that he had received from these funds in placing clients' hard-earned retirement savings into in the form of investments. And the law judge properly found him liable for violating the securities laws and properly sanctioned him with civil penalties, disgorgement, a cease and desist, and the industry bar. Now, what this appeal is about, Commissioners, is equally as important as what it is not about. Mr. Grossman is not challenging the sufficiency of the evidence. He is not challenging the nature of the charges. He's not challenging the appropriateness of the sanctions. He's not challenging the tier of the penalty. And as we heard Mr. Mesa concede earlier, he's also not challenging the cease and desist order or the industry bar. And so therefore, this appeal really is limited to what Mr. Grossman is challenging, namely, as we heard, the application of the statute of limitations and whether or not it bars the Commission's claims for disgorgement and a penalty. And so I'll address each of the arguments that I mentioned earlier. Now, the first is the waiver argument. As we all know, the 11th Circuit in Graham held that 28 U.S.C. 2462 includes a forfeiture among its terms, and the 11th Circuit found disgorgement to be the equivalent of a forfeiture. But Graham expressly declined to decide whether disgorgement constitutes a penalty. Now, that is the position that Mr. Grossman took in his petition on review and in his briefing. He did not argue in his petition for review that disgorgement constitutes a forfeiture. Now, under Rule 410B of the Commission's Rules of Practice, the Commission can exercise its discretion and find that a particular issue not enumerated in a petition for review is waived. And the Commission did just that in Timbervest, which was a decision that the Commission issued back in September, where the Commission found on this very point that there was no enumeration or argument by the respondent that disgorgement constitutes a forfeiture, and the Commission elected to exercise its discretion and find the issue waived. And so the division would ask that the Commission do the same here, and if the Commission does that, it would be unnecessary to decide whether Graham applies in this case. However, if the Commission does decide that a waiver is inappropriate and the Commission does decide that Graham is applicable, then the division, as my second point today, would submit that the Commission declined to follow Graham, and that's for three primary reasons. The first is that the Commission itself has held, as recently as Timbervest in September of 2015, that disgorgement is not a forfeiture and is not subject to the limitations period in 28 U.S.C. 2462. The second, as I referenced earlier, is that the staff has taken the position on behalf of the Commission in 3 separate appeals currently pending in the 2nd, the 8th, and the 10th Circuits that Graham was wrongly decided, and that's SEC v. Wiley in the 2nd Circuit, SEC v. Colliard in the 8th Circuit, and SEC v. Kokesh in the 10th Circuit. And that's because the Commission, like federal agencies in general, has the right to non-acquiesce in decisions of a single circuit court. And as the Commissioner mentioned earlier, Graham is in the minority. As a matter of fact, 2 circuits, the First Circuit in the Tambone case and the D.C. Circuit in Riordan, have both expressly concluded that disgorgement is not subject to the limitations period. And so to be consistent with the position taken in these appeals, the division would submit that the Commission declined to follow Graham, and the Commission can use this opportunity to explain the reasons why it believes that Graham was wrongly decided. And speaking of that, that takes me to my third point on this matter. The 3-judge panel in Graham had looked at, in their analysis, the reason why disgorgement constitutes a forfeiture. They limited the decision strictly to the modern dictionary definition of the term, ignoring the 200-plus year history and the fundamental distinctions between these 2 concepts that have existed since the 18th century. Disgorgement serves a remedial purpose. Its purpose is to return the parties to the status quo ante. That is the term the Commission itself has used. Forfeiture serves absolutely no remedial purpose. It is meant to punish. And in looking at these 2 concepts, the Commission need look no further than to the concept of a relief defendant. As we all know, we can seek disgorgement from a relief defendant in our enforcement actions without accusing that person of having committed any substantive securities violation. In a forfeiture proceeding, however, the government cannot seek forfeiture in the context of a criminal case against a third party without charging that party with a crime. So there is a distinction there. But if we are going to limit this to the definition in the dictionary, then we should do what Judge Garafis recently did in the Eastern District of New York and the Saltzman decision that came down a few weeks ago, and that's part of our supplemental filing, where Judge Saltzman looked to the definition of these terms as they existed in the 18th century. And Judge Saltzman found that at the time, forfeiture was a remedy to recover property that was used in the commission of a crime. And also, according to the dictionaries at the time, forfeiture was understood to be synonymous with a fine. Disgorgement, on the other hand, was a chancery court remedy that was used to order the repayment of ill-gotten gains. And Judge Garafis came to the conclusion that there are fundamental differences between those 2 just based on the dictionary definitions alone, to say nothing, of course, about the 200-plus year history of those terms. And the last point that I would like to make is with respect to the civil penalty. The Commission need not consider any of Grossman's misconduct that occurred prior to the limitations period. Instead, the Commission can focus just on the misconduct that he committed during the period. And that would be consistent with the Commission's recent decision in Dennis J. Maloof, where the Commission considered the misconduct that occurred during the limitations period. The division originally had advocated the continuing violation doctrine with respect to this issue, but on further reflection and based on the facts of this particular case, we believe that the Commission can still sanction Mr. Grossman just by looking at the misconduct he committed during the period. And in fact, the evidence at the final hearing showed that Mr. Grossman committed at least 15 separate instances of misconduct during the limitations period. And under Section 203I of the Advisors Act, each one of those instances can be sanctioned accordingly in penalties. Now let's look at this in a little bit more detail, and for point of reference, the division discusses this at length at pages 11 to 18 and 21 to 30 of our brief on appeal. The 5 investors who provided testimony at the hearing testified that Mr. Grossman continued to work with them on their investments, and despite a contradiction in the evidence as to what Mr. Grossman says, continued to advise them as to the merits of being in these anchor funds. During these interactions, Mr. Grossman neglected to tell these clients that he had not conducted the extensive due diligence that he had represented and had not told the clients about the risks of staying in these funds, something that any investment advisor should know better when it comes to funds that are not properly diversified.
Mr. Costello, if I may ask you, in what capacity do you contend that Mr. Grossman was acting within the statutory period, in light of his sale of Sovereign? And does it matter to your argument?
The sale, Chair White, is not relevant to our argument because Mr. Grossman demonstrated the evidence at the hearing showed that he continued to act as an investment advisor. Regardless of whether his registration that he left with the Commission until 2011, I might add, but regardless of that, his actions speak very loudly on this particular issue as to what he was doing.
I have a follow-up question to that. What compensation did he receive after November 20th, 2008, and what was the basis for the compensation?
The compensation that he received was limited to salary payments. At least the evidence showed at the hearing that it was limited to salary payments that he received from Sovereign. The division is not contending that he received any of these kickbacks or anything to that effect during the limitations period, with the exception of two particular instances where he had specifically recommended that clients swap their subclasses from Class C of the anchor funds to Class A of the anchor funds. And there was remuneration received, the kickbacks were received for that, but the bulk of the kickbacks, Commissioner, were received prior to the limitations period. And that was the measure of our disgorgement, or the primary measure of our disgorgement claim. And in addition to failing to disclose the due diligence that he had not conducted on these funds, he also neglected to tell them that remaining in these funds was risky, particularly in light of what was happening in the market at the time, and also that he had received kickbacks to the tune of $3.5 million. 5 separate investors, 2 separate omissions, 10 instances of misconduct under the Advisors Act calculation. And this was consistent, to go back to the Commissioner's question from earlier, with what they were representing to clients, both Mr. Adams and Mr. Grossman. In October of 2008, Mr. Grossman sent a letter to clients telling them that he was going to remain on the board of advisors of this company and be, quote, actively involved in operations, and also further consistent with in January of 2009 when he was introduced with an additional title of managing director of this entity, and clients testified that Mr. Grossman remained their advisor the way that they looked at it. So those are 10 instances. The other 2, to go back to what I said earlier about the 2 letters that we see in the evidence suggesting or recommending that clients swap their shares, and both of these clients acted on that. Again, you have the same 2 omissions that were committed with respect to this purchase of securities. So you have 2 different investors, 2 different omissions. There's 4 violations right there. Added to the first 10 now brings us to 14. And then the remaining violation with respect to the Form ADV Part 1 that was filed on December 23, 2008, there were a number of misstatements contained in that ADV. For example, in Item 6B of the ADV, it required the advisor, in this case Mr. Grossman, the gentleman who signed it, do you have any businesses other than giving investment advice? And the answer to that was yes. He was engaged in advisory management for the funds that his client was investing in. He told the examiners in this case that he acted as an investment advisor for the anchor funds, failed to disclose that. Item 7, relationships with investment companies and related parties. The ADV says no, that's not true. SIAM, the related entity to Sovereign, Anchor Holdings Florida, Anchor Holdings Nevis, each of these entities had relationships with the funds because that's how the money was being channeled back from the funds ultimately to Mr. Grossman through these intermediary entities. Item 8, do you recommend funds in which the advisor or related persons have proprietary or sales interests? Answer, no. That's also wrong because Mr. Grossman had a sales interest in these funds. He was getting remuneration, he was getting kickbacks, and so was Sovereign. Now, interestingly enough, these exact deficiencies in Item 7B and Item 8B3, the examiners, when they went out there, had told Mr. Grossman twice to fix these particular things or recommended that these particular things needed to be updated. You need to correct these answers because that doesn't reflect the reality. You're not saying what you do and you're not doing what you say. And Sovereign didn't correct that. Instead, he filed that with the Commission on December 23, 2008. So with respect to the ADV, the Commission can look at that as one violation, or as I've explained, it could be considered 3 violations, but the point is that you have at least 15 separate instances of misconduct. So just with those 15 violations during the period, the Commission can elect to sanction Mr. Grossman either with second or third tier penalties. If you choose the second tier, you have $65,000 because March 3rd, 2009 was the point of adjustment, so we'll go with $65,000 for point of reference. Times 15 is $975,000. If you go with a third tier penalty, you have $130,000 times 15, $1.95 million. So the division submits that the Commission can consider a range of between $975,000 and $1.95 million just based on the misconduct that Mr. Grossman committed within the period. The division believes, as we explained in our brief and as the law judge found, and evidently as Mr. Grossman is not disputing on appeal, that third tier penalties are appropriate because of the creation of the risk of significant loss to clients, and unfortunately that risk came to fruition because the clients, as I said at the outset, lost millions of dollars in this. Now, with respect to the misconduct that predates the limitations period, the question is, what about that? What relevance does it play in this case? For purposes of assessing and calculating the penalty, as I just explained, it doesn't. But the Commission itself, in the Guy P. Riordan case in 2009, said that with respect to conduct that would otherwise be time-barred, the Commission can still consider that for purposes of determining motive, intent, opportunity, course of conduct for looking at the misconduct committed during the period. In other words, the prior misconduct informs the current misconduct. And so the Commission can still look at that, not only for purposes of the cease and desist and the industry bar, which aren't being disputed here, but also to inform, for penalty purposes, what Mr. Grossman was doing within the period. And with respect to the prior misconduct, it's not as if this misconduct didn't happen. It did, and it was significant. And this is not as if it's a light switch where we simply turned it off simply because the limitations period starts. It still informs how this gentleman behaved during the limitations period. And so I'm not going to address the cease and desist in the industry bars. As Mr. Mesa indicated, Mr. Grossman is not contesting those on appeal. And so in conclusion, the division believes that the Commission should sanction Mr. Grossman with civil penalties based on the misconduct he committed during the period. And if the Commission determines that Graham is properly preserved for appeal and the Commission decides to consider Graham, the division would ask that the Commission decline to follow Graham in this instance and sanction Mr. Grossman with full disgorgement as the law judge had calculated. And the division would like, again, to thank the Commission for the opportunity to address you this afternoon. If the Commission doesn't have any questions, thank you.
Thank you very much. Mr. Mesa, you may proceed with your rebuttal.
The respondent did not waive the argument that disgorgement is subject to 2462 statute of limitations. Specifically in its brief, it brought up the Graham case, discussed it at length, and discussed its applicability to the current situation. So by virtue of not using forfeiture rather than penalty, I don't believe that rises to the level of a waiver. Division is correct. Division mentioned that the underlying wrong that the LOJ found with regards to Mr. Grossman placing his clients in the anchor funds was that he didn't adequately assess the risks. He didn't do the proper due diligence. Well, that occurred during his ownership of Sovereign. That occurred when those clients were placed into those funds. And any type of subsequent ill effects are not actionable under SEC v. Leslie. Now, with regards to Mr. Grossman's status after the sale of Sovereign, Mr. Grossman, there's been no evidence that any of his salaries or any of his payment with regards to his compensation as being a consultant is any way tied to the rendering of any investment advice. This issue has raised itself before, and I don't have the cite in front of me. However, it was in a sentencing hearing, and I'll provide you the cite, to where the government was seeking an upward departure and I guess, enhancement and sentencing hearing due to the violations occurred while the defendant was an investment advisor. The Southern District of New York declined to adopt any type of enhancement, mainly because there was no evidence that the investment advisor was receiving any type of compensation tied to any type of investment advice. With regards to the audit that the division was speaking of upon Sovereign, that audit occurred in 2004, nearly, what was that, almost 9 years before the OIP was filed. In between that time, there was a second inquiry in 2008. The SEC had the ability and did depose Mr. Grossman in 2012 and served a subpoena request on him that he responded to as well. Well before the expiration of the statute of limitations, the SEC had the ability to bring their claims in a timely fashion, and they elected not to do so or just overlooked their obligation to do so, as Graham has required. The division also mentioned the specific investment advice regarding the swap of shares that Mr. Grossman recommended from Anchor Hedge Fund C into PIWM. Specifically, those are at the division's exhibits, I believe, 113 and 113-1. During the hearing, there was ample testimony from Mr. Adams regarding that those were sent out in error. Those were not the actual swap documents, and in fact, the ALJ agreed with that by not considering that and rendering her determination of her amount of a penalty. So as to any type of determination as to whether or not Mr. Grossman had specifically recommended any type of investment advice to sovereign clients, that was discounted by the ALJ at the final hearing. Thank you for your time.
Thank you very much. Thank you both, counsel. The commission will take this matter under advisement, and our meeting stands adjourned.